The morning sun cast long shadows across the courthouse steps as Marcus Johnson checked his watch. 8:37 a.m. The municipal courthouse of Charleston, South Carolina stood before him, an imposing structure of weathered brick and marble columns that had witnessed generations of the city's legal proceedings. Golden light filtered through the oak trees lining the sidewalk, dappling the concrete with shifting patterns as early morning traffic hummed in the background. The air carried the distinctive saltiness of the nearby harbor, mixed with the sweet scent of magnolias blooming despite the early summer heat. Marcus straightened his charcoal gray suit and adjusted his crimson tie, a gift from his grandmother, whose property had brought him here today. At 38, Marcus Johnson had established himself as one of the most respected assistant United States attorneys in the Eastern District, known for his methodical preparation and unwavering commitment to justice. His tall frame and confident stride reflected the discipline that had carried him from Liberty Hill, one of Charleston's historically black neighborhoods, through Howard University Law School, and ultimately to the Department of Justice, where he'd spent the past 11 years prosecuting everything from human trafficking rings to complex corruption cases. Today, however, Marcus wasn't representing the federal government. He was here on a personal matter that had consumed his nights and weekends for 3 months, fighting an inexplicable property tax increase on his grandmother's home. The modest 2-bedroom house in Liberty Hill wasn't just real estate. It was his anchor, the place where Emma Johnson had raised him after his parents' accident, teaching him about justice and dignity long before he'd earned his law degree. The city's decision to raise the property taxes by 32% without proper notification felt like more than a clerical error. It felt personal, another example of the systemic pressures gradually pushing black families from their historic neighborhoods. Marcus had prepared meticulously for this hearing, gathering historical assessment records, comparable property valuations, and documentation of the city's failure to provide proper notice. The leather portfolio tucked under his arm contained everything necessary to challenge this unjustified increase. His grandmother couldn't afford the additional $1,200 annually on her fixed income, and the house that had sheltered 4 generations of their family shouldn't be threatened by arbitrary bureaucratic decisions. Marcus's phone vibrated in his pocket, the screen displaying "Federal Office Urgent." He exhaled deeply before answering. Agent Cooper's voice was tense. "Johnson, we've got movement on the Sullivan trafficking case. They've filed a motion to suppress evidence based on chain of custody. We need your input now." Marcus's jaw tightened. The Sullivan case had consumed 6 months of his life, a network trafficking young women across state lines into forced labor. "Send me the details. I'll review it now, but I have court in 20 minutes, he responded while opening his briefcase on the courthouse steps, his mind already splitting between 2 urgent priorities. As he quickly reviewed the documents, checking the time repeatedly, Marcus knew he'd be cutting it close for his court appearance. The tension began building in his shoulders. Being late to court went against everything he believed about professionalism, but some battles simply couldn't wait. Marcus passed through the security checkpoint of the municipal courthouse, the metal detector beeping softly as he placed his briefcase on the conveyor belt. The security guard, a heavyset man with salt and pepper hair, nodded in recognition. "Morning, counselor," he said with the easy familiarity of someone who had seen Marcus in the federal courthouse across town. "Slumming it with us today?" His smile suggested genuine warmth. Marcus returned the smile. "Just a personal matter, George. Property tax dispute, nothing exciting," he replied, collecting his belongings, though the friendly exchange momentarily lightened his mood. The interior of the municipal courthouse bore little resemblance to the federal building where Marcus spent most of his professional life. Gone were the marble floors, polished wood paneling, and atmosphere of solemn authority. In their place, worn linoleum tiles, scuffed benches, and walls painted an institutional beige decades ago. Fluorescent lights buzzed overhead, casting a harsh glow that flattened everything beneath them. The building itself seemed to reinforce the hierarchy of justice, where federal cases received grandeur, while everyday citizens navigated a more utilitarian version of the legal system. The air carried a distinctive blend of industrial cleaning products, stale coffee, and the unmistakable scent of anxiety that permeated spaces where people's fates hung in balance. Whispered conversations created a constant background hum, punctuated occasionally by the sharp sound of a door closing or a name being called. A water fountain gurgled inefficiently in the corner, providing inadequate relief from the building's overzealous heating system. Somewhere down the hall, a printer repeatedly jammed, causing administrative staff to curse under their breath as they attempted repairs. Every sound echoed slightly against the hard surfaces, creating an acoustic environment as institutional as the visual one. Marcus found a spot on a bench outside courtroom 204, using these final minutes to review his property tax documents. Around him, Charleston's diversity was on full display, though united by the common denominator of stress. A young mother sat nearby, attempting to quiet a restless toddler while simultaneously reviewing papers with nervous concentration. An elderly couple whispered intensely to each other, their expressions betraying worry about whatever had brought them here. A man approximately Marcus's age in a paint-splattered work shirt studied a traffic citation, his foot tapping an anxious rhythm against the floor. Two college students in university sweatshirts slouched against the wall, their attempted nonchalance betrayed by tense shoulders and darting eyes. A middle-aged woman in medical scrubs rifled through a manila folder, clearly having come directly from a night shift to make her court appearance. At precisely 8:55 a.m., the courtroom doors opened as a bailiff emerged, announcing that proceedings would begin shortly. The assembled crowd rose in near unison, shuffling toward the entrance. Marcus gathered his materials and joined the procession. The courtroom was larger than expected, with high ceilings that amplified every cough, whisper, and shuffling paper. The wooden benches, arranged in neat rows, faced the judge's bench, an elevated platform that quite literally placed the judge above everyone else in the room, a physical manifestation of authority. A door behind the bench opened precisely at 9 a.m., and the bailiff's voice rang out, "All rise. The Municipal Court of Charleston County is now in session. The Honorable Judge Richard Wilson presiding." Judge Wilson entered with measured steps, his tall frame draped in the traditional black robe, silver hair perfectly coiffed, wire-rimmed glasses perched on a prominent nose. His reputation had preceded him 27 years on the bench, known for running an efficient courtroom and having little patience for unprepared attorneys or excuses from defendants. His movements communicated practiced authority as he settled into his leather chair, briefly surveying the room before him with pale blue eyes that seemed to miss nothing. "Be seated," he instructed, his voice carrying effortlessly across the room without seeming to raise it. The audience complied in a rustle of clothing and creaking benches. Marcus observed the judge's demeanor carefully, noting the precise arrangement of items on his bench, the methodical way he reviewed the docket before him. Everything about Wilson suggested someone who appreciated order, structure, and deference to his authority. As the first cases were called, Marcus watched the judge's interactions, gathering valuable intelligence about his temperament and approach. As proceedings began, Marcus noticed a young white woman in business attire rush in, nearly colliding with a court officer as she hurriedly found a seat. Her arrival disrupted proceedings momentarily as heads turned toward the commotion. Judge Wilson barely glanced up, continuing without comment despite her obvious tardiness. 15 minutes later, a white college student in khakis and a polo shirt entered similarly late, slipping into the back row. The judge actually nodded, acknowledging him with what appeared to be a slight smile before continuing. Marcus made careful mental notes of each incident, his prosecutor's instincts already alert to patterns that most might overlook. Marcus Johnson. The clerk's voice echoed through the half-filled courtroom as Marcus gathered his documents and approached the podium. His stride was measured and confident, despite being 7 minutes late for his scheduled appearance. His leather portfolio rested precisely at the center of the wooden podium, open to reveal meticulously organized documents with color-coded tabs. He stood tall in his well-tailored suit, his posture communicating both respect for the court and self-assurance, born from years of prosecutorial experience. The fluorescent lights reflected off his neatly trimmed hair as he met Judge Wilson's gaze directly, prepared to address the property tax issue with the same precision he brought to federal cases. Judge Wilson looked up from his bench, steel-gray eyes narrowing as they locked onto Marcus. His expression hardened in a way that hadn't happened for the 3 previous cases, including 2 where defendants had arrived later than their appointed times. The atmosphere in the courtroom shifted perceptibly as the judge's fingers drummed once against the polished wood of his bench. "Mr. Johnson," Judge Wilson's voice cut through the room like ice, "it appears you believe your time is more valuable than this court's. Your case was scheduled for 9:20. It is now 9:27. He leaned forward slightly, glasses catching the light. "Perhaps in federal court, punctuality is considered optional, but in my courtroom, it demonstrates basic respect for this institution and the other citizens waiting for their cases to be heard." His tone carried a sharp edge that hadn't been present in earlier proceedings. "Do you have an explanation for your disregard of this court's schedule, or shall we add contempt to today's agenda?" The judge's reprimand hung in the air, disproportionate to the minor infraction, and noticeably different from his response to earlier latecomers. Every word seemed calculated to establish dominance and diminish the man standing before him. "Your Honor, I apologize for my slight delay," Marcus began, his tone respectful, but not deferential. His voice remained steady, modulated by years of courtroom experience. "I was addressing an urgent federal matter regarding a human trafficking case that required immediate attention." He maintained direct eye contact with the judge, neither confrontational nor submissive. "While I understand the importance of punctuality in your courtroom, my responsibilities as an assistant United States attorney occasionally create unavoidable conflicts. I've made every effort to arrange my schedule to be here today and appreciate the court's understanding." His explanation was concise and professional, offering context without making excuses, the same balanced approach that had served him well in countless federal proceedings. Judge Wilson's hand sliced through the air dismissively, cutting off any further explanation. "This court does not operate on your schedule, Mr. Johnson, regardless of what other matters you deem important. Tardiness shows disrespect for these proceedings and for every other citizen who managed to arrive on time." He shuffled papers on his bench with deliberate movements, a performance of bureaucratic authority. Federal prosecutor or not, the rules apply equally to everyone in this courtroom. The irony of this statement hung unacknowledged in the air given his earlier leniency. "You are hereby fined $750 for contempt of court. Perhaps this will serve as a reminder that punctuality is not optional in my courtroom." The pronouncement hung in the air like a thunderclap, a fine dramatically higher than any typically imposed for such minor infractions. The judge's expression remained stern, almost satisfied, as he added, "The clerk will provide you with payment information. Now, as to your property tax matter. The fine wasn't just excessive. It was vindictive, completely disproportionate to the 7-minute delay and starkly inconsistent with the judge's previous tolerance." Marcus maintained his composed exterior, but internally, his mind raced with analytical precision. This wasn't random or merely unfair. It was a pattern he had witnessed countless times throughout his career, though rarely so blatantly displayed. The white woman who had arrived 15 minutes late had received a small smile. The white college student who had disrupted proceedings had been acknowledged with friendly recognition. Yet his 7-minute delay warranted a punitive fine that would represent a significant hardship for many of Charleston's citizens. He recognized the familiar weight settling in his chest, not surprise, but the heavy recognition of a pattern deeply embedded in American justice. As a federal prosecutor, Marcus had dedicated his career to upholding the law equally for all citizens. Now he stood experiencing firsthand the selective application of equal justice that so many before him had described. The disparity wasn't subtle. It was as blatant as a neon sign, illuminating a truth that many in power worked diligently to obscure. Several spectators exchanged glances of surprise. The court clerk's fingers hesitated over her keyboard. A middle-aged black woman in the third row shook her head slightly, her expression conveying resigned familiarity rather than shock. Two law students in the back corner whispered to each other, one frantically scribbling notes. An elderly white man near the front frowned, discomfort evident in his furrowed brow. The young mother with her toddler glanced between Marcus and the judge, her eyes reflecting concern and uncertainty. Though these reactions were subdued, restrained by the formality of the courtroom and the power dynamics at play, they created a ripple of awareness throughout the space. The disparity had been witnessed, registered, and silently acknowledged by many present, even if most felt powerless to address it. As Marcus returned to his seat to collect himself, he pulled a small leather-bound notebook from his breast pocket. With calm deliberation, he began documenting every detail of what had just transpired, the exact time, the judge's words, the contrasting treatment of previous cases. His handwriting was precise and methodical, recording not just the fine, but the pattern it represented. This was no longer just about his grandmother's property tax issue. It had become about something far more fundamental. His legal mind was already calculating, analyzing, and preparing for what would come next. When his case was called again, Marcus approached the podium with renewed purpose. His demeanor remained professional and composed, his shoulders squared, his expression attentive but unreadable. The earlier confrontation had crystallized his focus, transforming his approach from routine advocacy to strategic documentation of a systemic issue. He arranged his exhibits with methodical precision, his movements economical and deliberate. Your Honor, I'm here regarding parcel number 157632, a residential property at 217 Liberty Hill Road, Marcus began, his voice clear and measured. This property, owned by Emma Johnson for the past 42 years, has experienced an unexplained 32% increase in assessed value, resulting in an annual tax increase of $1,248. He presented his first exhibit, a series of property tax assessments spanning 6 years. As these records demonstrate, the property's assessed value remained relatively stable from 2017 through 2022, with modest increases of 2 to 3% annually, consistent with typical property appreciation in Charleston County. He proceeded methodically through his evidence, presenting comparative assessments of similarly sized homes in Liberty Hill. Properties within a quarter-mile radius experienced average increases of only 4% during this same assessment period. None approached the 32% increase applied to my grandmother's property. He placed overhead satellite images on the podium, highlighting the location and comparable properties. Additionally, no significant improvements or renovations have been made to the property that would justify such a dramatic reassessment. Marcus then presented documentation of procedural violations. South Carolina Code Section 12-60-2510 requires written notice of assessment increases exceeding 15%, allowing property owners 60 days to appeal. As this certified mail receipt shows, notification was sent only 27 days before the appeal deadline, constituting a clear procedural violation, His presentation was thorough and precisely organized, the type of evidence that would typically receive careful consideration in any fair proceeding. Judge Wilson barely glanced at the carefully assembled documentation, his attention seemingly divided between the computer screen and his watch. He shuffled papers impatiently, the performance of a busy man whose time was being wasted. Mr. Johnson, while I appreciate your enthusiasm for detail, these matters are rarely as straightforward as property owners believe. Tax assessments involve complex calculations beyond simple comparisons to neighboring properties. The judge's tone carried the same dismissive quality he had used earlier, though now tinged with condescension. The city employs professional assessors who consider numerous factors invisible to laypeople: potential development value, infrastructure improvements, zoning changes. He waved his hand vaguely, not bothering to specify actual factors relevant to this case. As for the notification timing, minor procedural delays do not automatically invalidate legitimate assessments. The core issue is whether the valuation itself is appropriate, not whether paperwork arrived a few days later than ideal. His dismissiveness stood in stark contrast to his treatment of an earlier case, where a white property owner from an affluent neighborhood had presented far less documentation, yet received careful attention and consideration for his tax challenge. That case had resulted in an immediate adjustment, with the judge personally commending the petitioner's diligence in protecting their property rights. "Your Honor," Marcus responded carefully, "I understand the complexity of property assessments. However, the statutory requirement for 60-day notification isn't a mere suggestion, but a legal requirement designed to protect due process rights. Beyond that procedural issue, the comparative data I've presented shows a distinct pattern that requires explanation." He gestured toward his exhibits, maintaining a respectful tone while firmly advocating his position. When similarly situated properties experience consistent, modest increases while one property faces a dramatic 32% jump, it raises legitimate questions about assessment criteria and equitable application. He paused briefly, then continued with measured precision. "I'm curious, Your Honor, about the court's standard process for addressing such disparities. Earlier today, I observed Mr. Harrington's case involving a property in the historic district receive immediate adjustment when he presented comparative assessment data. I'm seeking to understand the different standards being applied to properties in Liberty Hill versus other neighborhoods." The question was carefully framed as procedural inquiry rather than accusation, yet it directly highlighted the disparity in treatment that had become increasingly evident throughout the morning's proceedings. Judge Wilson's face flushed slightly, a vein becoming visible at his temple. He leaned forward, hands gripping the edge of the bench, his previous veneer of bureaucratic indifference replaced by barely contained hostility. "Mr. Johnson, this court determines procedural matters, not you." His voice had dropped to a dangerous quiet. "Your attempt to draw inappropriate comparisons between unrelated cases suggests a troubling misunderstanding of judicial discretion. Each case is evaluated on its individual merits according to standards I am fully qualified to determine after 27 years on this bench." He straightened, adjusting his robe with sharp movements. "If you're suggesting some impropriety in how cases are handled in my courtroom, perhaps you should state that accusation clearly rather than hiding behind procedural questions. The challenge hung in the air, an attempt to force either confrontation or retreat." Marcus gathered his documents with calm deliberation, neither rushed nor intimidated by the judge's display of anger. His expression remained neutral, but his mind had shifted focus from the immediate tax dispute to the much larger issue now clearly documented through his own experience. This wasn't about $1,248 in annual taxes anymore. It was about a pattern of disparate treatment that affected countless citizens who lacked his legal training and professional position. He would address his grandmother's tax issue, but through different channels and as part of a more comprehensive approach to the systemic problem he had now witnessed firsthand. "Thank you for your time, Your Honor," he said simply, maintaining professional courtesy while mentally planning his next strategic steps. The afternoon shadows lengthened across the courtroom floor as the day's docket wound to a close. While other defendants and petitioners filed out, Marcus remained seated, reviewing his notes and waiting with deliberate patience. He watched Judge Wilson handle the final cases, observing patterns and inconsistencies with the trained eye of a federal prosecutor. The courtroom gradually emptied as 4:30 approached, leaving only the essential court personnel and a few lingering observers. By 4:45, the municipal court had transformed into a different space. The bustling energy of the morning had dissipated, leaving behind a hollow quietness punctuated only by the occasional shuffle of papers and the distant ringing of a phone down the hallway. Afternoon sunlight slanted through the high windows, casting long golden rectangles across the worn floor tiles. The once crowded benches now stood mostly empty, with just a handful of people remaining, a young law student in the back row, an elderly court observer who appeared to be a regular, and 2 administrative clerks gathering their belongings. The air felt charged with unspoken tension, that peculiar atmospheric weight that precedes significant confrontations. Judge Wilson remained at the bench, reviewing documents for the following day's proceedings, his silver hair catching the late afternoon light. The court clerk organized files with practiced efficiency, occasionally glancing toward Marcus with barely disguised curiosity about his continued presence. When the final case concluded, Marcus rose from his seat and approached the bench with measured, confident strides. His demeanor had subtly transformed from the deferential petitioner of the morning to something entirely different. His shoulders squared, chin slightly raised, his entire bearing projecting the authority that came naturally after years of representing the federal government in high-stakes prosecutions. Each step was deliberate and unhurried, his leather shoes making a distinct sound against the floor tiles that seemed to announce his purpose before he spoke. The notebook he had used earlier was nowhere in sight. Instead, he carried only his credentials in his breast pocket. The transformation wasn't merely physical, but emanated from a fundamental shift in purpose. This was no longer Marcus Johnson, the concerned grandson, but Assistant United States Attorney Johnson, stepping fully into his professional identity, the calm certainty of his mission evident in his unwavering gaze. "Your Honor," Marcus began, his voice carrying easily across the nearly empty courtroom, "I'd like a moment of your time before you conclude today's session." Judge Wilson glanced up, irritation flashing across his features at the interruption to his routine. "Mr. Johnson, the court session has concluded," the judge replied with the dismissive tone he had employed throughout their earlier interactions. "If you wish to address your fine or file an appeal regarding your property tax matter, you'll need to speak with the clerk during regular business hours." "With respect, Your Honor, I believe proper introductions are in order," Marcus replied evenly as he reached into his suit jacket, producing his credentials. "I'm Marcus Johnson, Assistant United States Attorney for the Eastern District of South Carolina. I've served with the Department of Justice for 11 years, specializing in human trafficking, organized crime, and civil rights violations." The words hung in the air with perfect clarity, each syllable precisely articulated. "The urgent federal matter I mentioned this morning involved the Sullivan human trafficking case. Perhaps you've seen it covered in the news. 18 victims rescued from forced labor across 3 states, with connections to international criminal organizations." His tone remained professional, neither apologetic nor confrontational, simply stating facts with the confidence of someone accustomed to being heard in federal courtrooms. "My appearance today was indeed personal. My grandmother's property matters greatly to me, but my professional obligations and identity remain relevant to how I was treated in this courtroom." Marcus held his federal credentials where the judge could clearly see them, the gold Department of Justice badge gleaming in the afternoon light, his photo ID card with its official security features clearly visible alongside it. The credentials weren't merely identification. They represented federal authority and 11 years of distinguished service prosecuting some of the region's most significant cases. He held the badge slightly longer than necessary, ensuring that everyone remaining in the courtroom could recognize its significance. The embossed Department of Justice seal and United States Attorney designation were unmistakable symbols of his position within the federal justice system. The credentials served as a silent reminder that the man who had been treated dismissively all day operated at the highest levels of American jurisprudence, trying cases before federal judges and working directly with FBI and Homeland Security investigations. Judge Wilson froze, his hand stilling over the papers he had been shuffling. The transformation was immediate and profound, the blood visibly draining from his face as understanding dawned. His mouth opened slightly then closed, lips pressing into a thin line as he struggled to recalibrate his response to the man standing before him. The pen he had been holding slipped from his fingers, landing on the bench with a small but audible tap that seemed to punctuate the moment. The judge's breathing pattern changed perceptibly, becoming slightly more rapid as he straightened in his chair. His left hand moved unconsciously to adjust his tie beneath his judicial robe, a nervous gesture that betrayed his discomfort. The authority he had wielded so confidently throughout the day suddenly seemed to diminish, not through any formal challenge, but through the simple revelation of who exactly he had been dismissing and fining. I see, he finally managed, his voice having lost its earlier commanding tone. Had I been aware of your position this morning, perhaps we could have made accommodations for your federal responsibilities. The statement only confirmed what Marcus had observed all day, that justice in this courtroom varied depending on who stood before the bench. This morning's interaction has raised serious concerns about the disparate application of rules in this courtroom. Your Honor, Marcus continued, his voice measured and precise. As an officer of the federal court, I have an obligation to report potential patterns of bias or discrimination when I observe them. Today, I witnessed multiple individuals arrive later than I did, some significantly so, yet received no comment or reprimand whatsoever. He maintained direct eye contact with the judge, neither aggressive nor submissive. The $750 fine imposed on me appears to be dramatically inconsistent with standard penalties for minor tardiness, if such penalties exist at all. Similarly, the dismissive treatment of my grandmother's property tax case contrasts sharply with the careful consideration given to similar cases from other neighborhoods presented earlier today. His words carried the weight of professional assessment rather than personal grievance. These inconsistencies, when viewed together, suggest a pattern of differential treatment that may violate the fundamental principle that all citizens deserve equal treatment under the law, regardless of their race, neighborhood, or other characteristics. This isn't about me personally, Your Honor. It's about ensuring that everyone who enters this courtroom receives the same measure of justice. The young law student in the back row had stopped pretending to review notes, now openly watching the exchange with wide-eyed fascination, scribbling frantically in her notebook. The court clerk had frozen in place, files half organized in her hands, her expression a mixture of vindication and anxiety, someone who had witnessed similar patterns for years, but never expected to see them confronted so directly. The bailiff, James Williams, a black man who had served in this courtroom for 15 years, stood straighter near the door, his face carefully composed, though his eyes revealed a complex emotional response to what was unfolding. The administrative assistant near the clerk's station dropped her gaze to her computer screen, but her fingers had stopped typing, every sense clearly attuned to the unprecedented confrontation. Most telling was the elderly court observer in the corner, who nodded almost imperceptibly, as if witnessing the confirmation of something he had observed for decades but never expected to see addressed by someone with the authority to demand accountability. The morning after his confrontation with Judge Wilson, Marcus sat in his federal office surrounded by stacks of case files related to the Sullivan trafficking network. Sunlight streamed through vertical blinds, illuminating dust particles in the air as the office hummed with the usual activity of the U.S. Attorney's Eastern District headquarters. His desk phone rang at 9:15, displaying his supervisor's extension. Sarah Chen, the U.S. Attorney for the Eastern District of South Carolina, had requested an immediate briefing. A formidable prosecutor with 15 years of experience including significant civil rights cases, Chen had been appointed 3 years earlier after distinguished service in the Justice Department's Civil Rights Division. Marcus wasn't surprised by the call. News traveled fast within the legal community, especially when it involved confrontations between different branches of the justice system. "Marcus," she said as she settled into the chair across from his desk, her expression a mixture of concern and curiosity, "I've heard some interesting rumors about your adventure in municipal court yesterday." Judge Wilson apparently called the chief judge this morning, though his complaint was unusually vague. "I'd like to hear your version before the gossip evolves further." Marcus recounted the events in precise detail, from the disproportionate fine for minor tardiness to the pattern of differential treatment he'd witnessed throughout the morning to his decision to reveal his position after the proceedings concluded. Chen listened without interruption, her expression growing increasingly serious as the pattern became clear. "It wasn't about the money, Sarah," he concluded. "It was the unmistakable pattern. I observed multiple white defendants arrived later than I did without comment, yet I was singled out for a punitive fine that far exceeded any reasonable penalty. When combined with the dismissive treatment of the property tax case compared to similar cases from predominantly white neighborhoods, the pattern becomes difficult to ignore." By early afternoon, Marcus had assembled a small team in the conference room overlooking Charleston Harbor. 2 paralegals with backgrounds in statistical analysis volunteered to assist, along with Lydia Fernandez, a junior prosecutor who had previously worked in civil rights litigation. The whiteboard was already filled with preliminary observations and an investigation framework as the team discussed strategy. "We need to approach this exactly as we would any other civil rights investigation," Sarah advised, standing near the window. "Methodical evidence collection, statistical analysis, witness testimony, and pattern documentation. If what Marcus observed represents a systemic issue rather than an isolated incident, we need compelling evidence that would stand up to scrutiny." Marcus nodded in agreement. "We should begin with public records, court transcripts, fine schedules, case outcomes. Let's focus initially on Judge Wilson's courtroom for the past 5 years, analyzing patterns in fines, sentencing decisions, and procedural rulings to determine if there are statistically significant disparities based on race or neighborhood." The team divided responsibilities efficiently. One paralegal would focus on fine amounts and payment plans, another on case outcomes and sentencing patterns, while Lydia would examine procedural rulings such as continuance requests and evidence admissions. They worked with the quiet intensity of professionals who understood the significance of their task, knowing that challenging a sitting judge would require irrefutable evidence. Within days, the initial data revealed disturbing patterns. Marcus stayed late into the evening, analyzing court records that painted an increasingly troubling picture of disparate justice. Spreadsheets covered his desk as he cross-referenced cases, documenting instances where nearly identical infractions received dramatically different penalties depending on the defendant's race. "The numbers are undeniable," he explained to Sarah during their follow-up meeting 3 days later. Black defendants in Judge Wilson's courtroom received fines averaging 273% higher than white defendants for identical violations over the past 5 years. Traffic offenses, code violations, minor infractions. The pattern holds consistent across categories. He displayed a series of graphs illustrating the disparities. Moreover, when we control for factors like prior records, representation status, and plea entries, the racial disparity actually increases rather than diminishes. Black defendants were denied payment plans at 4 times the rate of white defendants, even when presenting identical financial hardship documentation. The evidence extended beyond financial penalties to procedural decisions. Continuance requests from white attorneys were granted at an 87% rate, while identical requests from black attorneys were approved only 34% of the time. The data reveals a comprehensive pattern of disparate treatment that cannot be explained by legally relevant factors. Simultaneously, Marcus began reaching out to defense attorneys who regularly practiced in Judge Wilson's courtroom, his approach careful and confidential. Their responses proved illuminating, though many spoke only on condition of anonymity, fearing retaliation against future clients. He met with them in coffee shops, parks, and after hours in their offices, building a network of witnesses who could corroborate the statistical patterns with firsthand experiences. "I've been adjusting my strategies based on my client's race for years," admitted Patricia Winters, a veteran public defender with 20 years of experience. "With white clients, I can be aggressive, advocate strongly, push for leniency. With black clients, I have to be deferential, almost apologetic, or the judge becomes punitive. It's just how things work in that courtroom." Another attorney, Robert Kleinfeld, shared detailed notes he'd kept documenting the stark differences in how his clients were treated. "I started tracking this 3 years ago because the pattern was so obvious. I've been telling my black clients to wear suits, bring family members, write character references, anything to counteract the presumptions they face. Even then, the outcomes show consistent disparities." The stories accumulated rapidly, each one adding human context to the statistical evidence. Marcus interviewed defendants who had appeared before Judge Wilson, carefully selecting cases where similarly situated individuals had received dramatically different treatment. Michael Townsend, a black high school teacher, described how his request for a reduced fine due to financial hardship was summarily denied without consideration. "The judge wouldn't even look at my pay stubs or family medical bills," he recalled during an interview in Marcus's office. "Just said rules are rules and I should have thought about consequences before violating city ordinances." This contrasted sharply with the case of Thomas Bergman, a white defendant with a similar violation who was granted not only a reduced fine, but an extended payment plan after a brief explanation of his circumstances. By the end of the second week, word of the investigation had begun to spread through Charleston's legal community. Marcus received a call from Elisa Sanchez, a reporter with the Charleston Daily Chronicle, who had heard rumors of a federal prosecutor examining patterns in the municipal court. "I understand you can't comment on an ongoing investigation," she said when Marcus maintained appropriate reserve. "But is it accurate that the U.S. Attorney's Office is reviewing allegations of racial disparities in Judge Wilson's courtroom?" Though Marcus provided only a standard no-comment response, the following day's paper carried a front-page headline: "Federal Scrutiny. Local Judges' Rulings Under Investigation." The article carefully avoided direct accusations but noted, "Sources within the legal community confirm that statistical analysis of court records has raised concerns about consistent patterns in how different defendants are treated based on race and neighborhood." The public spotlight had turned toward a system long accustomed to operating without scrutiny, and the dynamics of the investigation were about to change dramatically. By the third week of the investigation, the Charleston County Judicial Review Commission had been formally convened, an extraordinary step that hadn't occurred in nearly 2 decades. The 7-member commission included retired judges, ethics experts, and community representatives appointed by the state Supreme Court with a mandate to investigate the mounting evidence of systematic bias. They established headquarters in a conference room on the third floor of the county administration building, walls soon covered with charts, statistics, and case timelines. Commissioner Elaine Rodriguez, a former federal judge with a reputation for unflinching integrity, was appointed to lead the inquiry. "Our mandate is clear," she announced during the commission's first public session. "We will examine the evidence without prejudice or presumption, guided solely by our commitment to equal justice under law." This investigation isn't about one judge or one courtroom. It's about ensuring that our judicial system fulfills its fundamental promise to treat all citizens fairly regardless of race, economic status, or background. Catherine Patterson entered the commission hearing room on the fourth day of testimony, her hands trembling slightly as she clutched a small leather-bound notebook. Having served as court clerk in Judge Wilson's courtroom for 17 years, she had uniquely intimate knowledge of the patterns now under investigation. The 58-year-old grandmother of 3 had risked her career and pension by coming forward, her weathered face reflecting both anxiety and resolve as she took the oath before testifying. "I started keeping these notes 7 years ago," she explained, placing the notebook on the table. "I didn't plan to. It just happened one day after I watched a young black mother get a $500 fine for a minor code violation, while a white college student with 3 previous violations received a warning for the same offense. Something broke inside me." She opened the notebook, revealing pages of meticulous documentation, dates, case numbers, defendants' names, violations, and outcomes, all recorded in neat handwriting during lunch breaks and after hours. "I knew it was wrong to stay silent, but I'm a single grandmother raising 3 grandchildren after my daughter's accident. I couldn't risk losing my job." Her voice steadied as she continued. "But I couldn't stop seeing the patterns either, so I started documenting everything: different bonds for the same charges, different fines for identical violations, different tones and language depending on who stood before the bench. It wasn't occasional. It was every single day, year after year." The notebook, spanning 7 years of careful observation, would become a cornerstone of the commission's findings. James Williams, the veteran bailiff who had served in Judge Wilson's courtroom for 15 years, provided testimony that corroborated and expanded on Patterson's documentation. The 55-year-old court officer stood ramrod straight at the witness table, his uniform pressed and immaculate, his testimony delivered with the steady calm of someone who had seen too much to remain silent. "I've watched black defendants get interrupted 30 seconds into their explanations while white defendants were allowed to speak for minutes," he testified, his deep voice carrying easily through the hearing room. "I've seen identical cases result in completely different outcomes based on nothing more than who was standing at that podium." Williams described overhearing comments made by the judge when attorneys and defendants weren't present, casual remarks that revealed underlying biases guiding judicial decisions. When a young black man was late because his bus broke down, he got a $500 fine. When a white college student was late because he overslept, he got a warning and a joke about college life. Williams described how courtroom security protocols were applied differently based on who was entering. Black families subjected to additional scrutiny, while white defendants and their families moved through with minimal inspection. "I followed orders and kept quiet for 15 years, he concluded. "I can't stay silent anymore. Not if I want to look my grandchildren in the eye." Dr. Eleanor Washington, a data scientist specializing in institutional patterns of discrimination, presented the commission with a comprehensive statistical analysis that transformed anecdotal observations into irrefutable evidence. Her presentation included multicolored graphs, regression analyses, and statistical controls that demonstrated the systemic nature of the disparities. The data reveals that when controlling for all legally relevant variables, prior records, offense severity, representation status, plea entries, black defendants were 3.7 times more likely to receive maximum fines, 2.9 times less likely to have requests for continuances granted, and received on average 40% less speaking time during proceedings, she explained, highlighting key findings on her presentation. The disparities extended beyond criminal matters to civil cases as well. Property disputes involving predominantly black neighborhoods were dismissed at 3 times the rate of identical disputes in predominantly white areas. Tax assessment challenges from Liberty Hill, a historically black neighborhood, were rejected at an 86% rate, while challenges from Harbor View, a predominantly white neighborhood, were successful 74% of the time. Dr. Washington's analysis covered 5 years of cases, examining over 2,300 proceedings to establish statistically significant patterns that could not be explained by coincidence or individual case factors. The consistency of these disparities across different types of cases, different time periods, and different contextual factors establishes a pattern that cannot be attributed to legally relevant distinctions between cases. The only variable that consistently predicts these differential outcomes is the race of the defendant or petitioner. Judge Wilson initially remained silent as evidence mounted, but as public pressure increased, he released a statement through his newly hired attorney and public relations firm. "My record of service to this community spans 27 years of dedication to upholding the law equally for all citizens," the statement read. These allegations, based on selective interpretation of complex judicial decisions, fail to account for the many factors that influence court proceedings. The statement continued, attempting to reframe the investigation as politically motivated. Every judge knows that maintaining proper decorum and respect for court procedures is essential to the administration of justice. Attempts to characterize appropriate judicial management as bias represent a fundamental misunderstanding of how courtrooms must function. The statement concluded by expressing confidence that a full and fair review will vindicate my record of impartial service. The response did little to quell growing community outrage as details from the investigation became public. Weekend demonstrations outside the courthouse grew from dozens to hundreds of participants, carrying signs reading, "Equal justice under law for everyone," and "Accountability now." Community forums in churches and community centers across Charleston drew overflow crowds, with citizens sharing their own experiences with disparate treatment in the courts. Reverend James Thornton of First Baptist Church addressed a gathering of over 300 people. "This isn't about one judge. It's about a system that has failed its foundational promise to provide equal justice. We're not asking for special treatment, we're demanding the equal treatment guaranteed by our Constitution." Judge Wilson, once a fixture at legal community events and civic functions, found himself increasingly isolated as the evidence mounted. Invitations to speak at law schools were rescinded. Colleagues began maintaining professional distance. Even his regular table at the Charleston Club, where he had lunched with other judges for decades, often remained empty as former associates avoided association with the growing scandal. The pressure of public scrutiny and professional ostracism began to show in his appearance, the once commanding presence now looking tired and defensive during his increasingly rare public appearances. News of what happened in Judge Wilson's courtroom spread far beyond Charleston, capturing national attention as major media outlets dispatched reporters to the historic coastal city. 3 weeks into the investigation, the Washington Post published an in-depth feature titled "Justice Deferred: Systematic Bias in a Southern Courtroom," while CNN aired a special report examining the implications beyond South Carolina. Legal analysts across political spectrums debated the significance of the findings on cable news panels, many pointing out that the methodical documentation made this case different from previous allegations of judicial bias. "What distinguishes the Charleston situation," noted a prominent legal scholar on a national morning show, "is the extraordinary level of documentation, statistical evidence, contemporaneous records kept by court personnel, and consistent testimony across multiple witnesses. This isn't a matter of perception or isolated incidents. It's a comprehensive picture of systematic disparities that challenges fundamental assumptions about how our courts operate. The story gained further momentum when national civil rights organizations announced plans to conduct similar statistical analyses in municipal courts across the country, suggesting that Charleston might represent not an anomaly, but rather a particularly well-documented example of a nationwide pattern. Social media transformed the local investigation into a national conversation about judicial accountability. Hashtags like #JudgeWilsonResign and #EqualJustice now trended on multiple platforms, with thousands sharing their own experiences of courtroom discrimination. The law student who had witnessed Marcus's confrontation with Judge Wilson posted a detailed account that went viral, receiving over 3 million views and 40,000 shares within 48 hours. Court observers and citizen journalists began attending proceedings in Wilson's courtroom, documenting every interaction on social media, creating unprecedented public scrutiny of routine municipal court operations. A TikTok video showing the judge treating similar cases differently based on defendants' race received over 5 million views, bringing the technical legal issues into stark relief for a broader public audience. Online advocacy groups created databases where citizens could report their experiences with local judges nationwide, attempting to identify similar patterns in other jurisdictions. The digital movement transformed an isolated investigation into a nationwide reckoning with questions of judicial accountability. The spotlight that initially focused on Judge Wilson soon widened to illuminate other courtrooms. Judges throughout South Carolina found their records and patterns subjected to new scrutiny as legal observers, inspired by the Charleston investigation, began documenting disparities in their own jurisdictions. Several judges in neighboring counties quietly began reviewing their own practices, some implementing voluntary recording of demographic data related to court outcomes. Judge Michaels, who served in Columbia's municipal court, contacted Marcus privately. "I've been reviewing my own records since your investigation became public," she admitted. "I found disparities I hadn't recognized, not as extreme as Wilson's, but concerning nonetheless. I've implemented changes, but I'm troubled by how invisible these patterns were to me despite my commitment to fairness." Similar reckonings occurred across the state as conscientious judges confronted their own potential blind spots. Several judges began requesting implicit bias training for themselves and their staff, a tacit acknowledgement that even well-intentioned judicial officers might contribute to disparate outcomes without conscious awareness. The State Judicial Council announced plans to implement systematic outcome tracking in all courts, a preventative measure designed to identify problematic patterns before they became entrenched. Not everyone welcomed the increased scrutiny. Judge Wilson's colleagues from neighboring jurisdictions had begun closing ranks, several issuing statements supporting his distinguished career of service and questioning the politically motivated attack on judicial independence. The Charleston Legal Society, comprised mostly of established attorneys from large firms, published an open letter expressing concern about rushing to judgment and undermining public confidence in our institutions. Their carefully worded statement avoided direct denial of bias while attempting to relocate the problem from discriminatory practices to their exposure. "Our justice system depends on respecting judicial discretion and the complexity of legal decision-making," this statement read. "Selective statistical analysis without proper context threatens to undermine the independence essential to fair adjudication." Several prominent attorneys publicly criticized Marcus's methods, suggesting that addressing concerns through proper channels would have been more appropriate than what they characterized as a public spectacle. Theodore Lancaster, a former Bar Association president, told reporters, "There are established procedures for addressing judicial conduct concerns." Bypassing these processes in favor of media attention raises questions about the true objectives of this investigation. Marcus faced mounting professional pressure as the investigation expanded. Several senior attorneys in his own office expressed concern about rocking the boat, suggesting the investigation might strain relations with local judges they needed to work with on other cases. His caseload increased as some colleagues became reluctant to collaborate with him, fearing association with controversy. Anonymous notes appeared in his office mailbox, some expressing support, others containing veiled threats about career consequences for challenging the status quo. A senior partner at a prestigious firm pulled Marcus aside at a bar association event. "You're making powerful enemies, son," he said, his voice low despite the crowded room. "Wilson has friends on the federal bench, friends who determine which cases get priority, which investigations receive resources. You're young, got a promising career, think carefully about the battles you choose." The pressure extended beyond professional circles. Marcus found himself being followed by private investigators, hired to find potential compromising information. His phone received multiple suspicious calls, and his home address was accidentally published on an online forum frequented by Wilson's supporters. Despite these challenges, Marcus found unexpected support networks forming around the investigation. The Charleston Community Justice Coalition, formed in response to the investigation, brought together church leaders, civil rights activists, community organizers, and concerned citizens across racial and economic lines. They organized courthouse monitoring programs, community education forums, and support rallies that drew increasingly diverse participation. The Liberty Hill Neighborhood Association, representing the historically black community where Marcus's grandmother lived, held weekly meetings to gather testimonials and provide emotional support to those coming forward with their experiences of court bias. "What you're doing matters to generations not yet born," Emma Johnson told her grandson during Sunday dinner. "Every story shared heals something in the person telling it, letting them know they weren't crazy for feeling the system was stacked against them." The legal community itself fractured along complex lines that transcended simple politics or demographics. Some of Wilson's strongest critics came from conservative legal traditions, attorneys who viewed equal application of the law as a fundamental conservative principle. "This isn't about politics. It's about whether we actually believe in rule of law," stated Richard Hargrove, a veteran prosecutor with Republican credentials. "Either we mean equal justice under law, or those words on the courthouse are just empty marketing." Younger attorneys overwhelmingly supported the investigation, many expressing relief that long-standing patterns they had observed were finally being addressed. The Charleston Bar Association's Young Lawyers Division issued a statement supporting transparency, accountability, and commitment to equal justice, while offering pro bono services to individuals who believed they had experienced discrimination in local courts. The division within the legal community reflected deeper questions about professional responsibility and the purpose of the justice system itself, questions that would continue reverberating long after Judge Wilson's case was resolved. 6 weeks into the investigation, the Judicial Review Commission released its preliminary report, a comprehensive 3-for-7-page document that sent shockwaves through South Carolina's legal community. The findings, based on statistical analysis of over 2,300 cases, testimony from 47 witnesses, and thousands of pages of court records, painted a devastating picture of systematic discrimination that could no longer be dismissed as isolated incidents or misunderstandings. The patterns documented in Judge Wilson's courtroom represent a profound and persistent failure to uphold the fundamental principle of equal justice under law, the report stated in its executive summary. Black defendants were 3.7 times more likely to receive maximum allowable fines than white defendants for identical offenses, even when controlling for all legally relevant variables, including prior records, representation status, and plea entries. The disparities extended beyond criminal matters into every aspect of the court's functioning. Property tax disputes from predominantly black neighborhoods were rejected at rates 213% higher than identical challenges from predominantly white areas. Procedural accommodations such as continuances and payment plans showed similar disparities, with requests from black defendants or their counsel denied at rates between 250% higher than those from white defendants in comparable circumstances. Most damning was the Commission's assessment that these patterns reflect not occasional lapses in judgment, but rather a systematic application of different standards based primarily on race, a pattern so consistent over time and across different types of cases that it cannot be attributed to coincidence, individual case factors, or judicial discretion properly exercised. 3 days after the preliminary report's release, Judge Richard Wilson submitted his resignation letter to the South Carolina Supreme Court. The announcement came through his attorney rather than a personal appearance, effective immediately and without the customary notice period. The carefully crafted statement released to the media struck a tone that acknowledged the controversy without admitting wrongdoing. After 27 years of dedicated service to the Charleston community, I have made the difficult decision to step down from the bench effective immediately. While I categorically reject any suggestion of improper conduct or bias in my courtroom, I recognize that the controversy surrounding recent allegations has become a distraction from the important work of our municipal court. I believe this decision is in the best interest of the court system I have long served, allowing the community to move forward without further division. I remain proud of my record of service and am grateful to those who have supported me throughout my career. The resignation, though presented as voluntary, came amid reports that the full commission findings would recommend disciplinary proceedings that could have resulted in removal and potential disbarment. Within hours of Wilson's resignation, the Chief Justice of the South Carolina Supreme Court announced emergency measures for Charleston's municipal court. The integrity of our judicial system depends entirely on public trust and confidence that all who enter our courtrooms will be treated equally and fairly under the law, this statement began. Recent events have highlighted the need for renewed vigilance in upholding this sacred principle. The immediate reforms included mandatory recording of all court proceedings with transcripts available for public review, implementation of a standardized fine schedule to reduce subjective penalties, and appointment of a diverse oversight panel to review court outcomes monthly for potential disparities. An interim judge with experience in civil rights law would be appointed while a national search was conducted for Wilson's permanent replacement. Additionally, the court announced new transparency measures requiring judges to articulate specific reasons for rejecting standard penalties or procedural accommodations, with these justifications becoming part of the public record. Case assignment would now operate on a random basis to prevent selective distribution of cases, and all payment plan requests would be evaluated using standardized financial criteria rather than subjective assessment. Perhaps most significantly, the reforms included creation of a new position, court equity officer, responsible for ongoing monitoring of outcomes, addressing complaints about disparate treatment, and ensuring implementation of reforms across all aspects of court operations. The State Judicial Board, recognizing that the problems extended beyond a single courtroom, announced the formation of a judicial equity task force charged with examining court procedures throughout South Carolina. While the Charleston investigation focused on one jurisdiction, we would be naive to believe these issues are isolated to a single courtroom or judge, the board's statement acknowledged. The task force would conduct a comprehensive review of court procedures, outcomes, and practices in all 86 municipal and magistrate courts across the state, with particular attention to potential racial disparities in fines, bail determinations, procedural rulings, and case outcomes. Every court would implement demographic data collection on outcomes, creating unprecedented transparency in a system that had historically operated without such accountability. The board announced that all judges would undergo mandatory quarterly training on implicit bias and fair practices, developed in partnership with national experts in judicial ethics and civil rights law. The comprehensive program went far beyond typical diversity training to address specific decision points where bias most commonly affected judicial outcomes, including credibility assessments, discretionary rulings, and sentencing decisions. This training isn't about political correctness or abstract theory, explained Dr. James Harrison, who headed the curriculum development team. It's about practical techniques to ensure that judicial decisions are based on legally relevant factors rather than unconscious assumptions or biases that all humans possess to some degree. The training would include review of participants' actual ruling patterns, providing judges with data about their own decision-making and potential blind spots, along with concrete strategies to ensure more consistent application of legal principles regardless of who appeared before them. Oversight committees comprising legal professionals, community representatives, and civil rights experts were established at both state and local levels to monitor implementation of reforms. The Charleston Committee for Judicial Equity, consisting of 12 members reflecting the community's diversity, would review monthly data on court outcomes, conduct regular courtroom observations, and issue quarterly public reports on progress toward equitable treatment. Similar committees were established in each judicial circuit, creating a statewide network of citizen oversight unprecedented in South Carolina's history. These committees were granted authority to access court records, observe proceedings, and make recommendations directly to the state Supreme Court regarding areas needing additional reform or intervention. Transparency and accountability aren't threats to judicial independence. They're essential to maintaining public trust in our courts, noted Commissioner Rodriguez at the announcement of these measures. A truly independent judiciary must be free from both external pressure and internal bias. Public reaction to the resignation and reforms reflected the community's complex relationship with its justice system. Many Charleston residents, particularly those from communities most affected by disparate treatment, expressed cautious optimism about the changes while remaining skeptical about how deeply they would transform entrenched practices. "It's a start," said Reverend Thornton at a community meeting following the announcement. "But systems don't change overnight, and paper reforms need real implementation to matter. We'll be watching, participating, and holding the system accountable every step of the way." Others expressed concern about Wilson becoming a scapegoat for systemic problems. "One judge resigning doesn't fix a system that's been broken for generations," noted community activist Desiree Washington. "We need to ensure these reforms have teeth and longevity beyond the current spotlight." The business community generally supported the changes, recognizing that perceived bias in local courts affected Charleston's reputation and economic development. "For our city to thrive, all citizens must have confidence that they'll be treated fairly by our institutions," the Chamber of Commerce stated, pledging support for implementation of the reforms. 6 months after Judge Wilson's resignation, the Charleston Municipal Court had undergone a transformation, both physical and operational. The building's interior had been renovated, replacing harsh fluorescent lighting with natural illumination from previously covered windows. The worn benches were refinished, walls repainted in warmer tones, and informational signs in multiple languages welcomed visitors with clear guidance about court procedures and resources. Beyond cosmetic changes, the atmosphere itself had shifted. Court officers greeted visitors with professional courtesy regardless of appearance or neighborhood, and the tension that had previously permeated the space had noticeably diminished. The lobby now featured electronic displays showing real-time information about case scheduling, available resources, and court outcomes data, physical manifestations of the new transparency initiatives. Most significantly, the renovated courthouse included a dedicated Office of Court Equity, prominently located near the main entrance, a visible commitment that oversight and accountability were now central to the court's mission, rather than external impositions. The procedural changes proved even more substantial than the physical renovations. Every court session now began with a clear explanation of participants' rights and available resources, delivered in straightforward language rather than the legal jargon. Standardized fine schedules were publicly posted, and any deviation required specific written justification from the presiding judge, automatically flagged for review by the Oversight Committee. A comprehensive case management system tracked judicial decisions by demographic factors, automatically identifying potential disparities for review while preserving the independence of individual decision-making. Judges received quarterly reports of their own ruling patterns compared to statistical averages, a mirror that reflected potential blind spots without public shaming. Payment plans for fines were now evaluated using transparent financial criteria rather than subjective impressions, resulting in approval rates that no longer varied by race or neighborhood. Legal assistance was available on site for those who couldn't afford private representation, with law students from local universities providing guidance under attorney supervision. Perhaps most transformatively, the court had implemented a community service alternative for those unable to pay financial penalties, recognizing that excessive fines often trapped vulnerable citizens in cycles of debt and additional violations. This program, developed in consultation with neighborhood associations and social service agencies, allowed individuals to contribute meaningfully to their communities while fulfilling their legal obligations. Catherine Patterson, the court clerk whose secret notebook had provided crucial evidence during the investigation, now directed the newly established Court Transparency Office. Her decades of experience combined with moral courage made her uniquely qualified to lead implementation of the reforms she had risked her career to make possible. For years, I documented problems with no power to address them, she explained to a group of clerks during their training session. Now, we're building systems where everyone has both the responsibility and the authority to ensure fair treatment. Her office conducted regular audits of court records, monitored compliance with new procedures, and served as a safe channel for employees to report concerns without fear of retaliation. Patterson had assembled a diverse team that included both veteran court employees and new hires with backgrounds in civil rights and data analysis, creating a blend of institutional knowledge and fresh perspectives that proved particularly effective in identifying both progress and continuing challenges in implementation. Marcus Johnson maintained his position at the U.S. Attorney's Office, but now dedicated one day each week to teaching a seminar on ethical advocacy and systemic justice at Charleston Law School. His classroom consistently overflowed with students eager to learn from someone who had demonstrated the practical application of legal ethics beyond theoretical principles. "The law gives us tools," he explained during an early lecture, "but our conscience must guide how we use them. Privilege comes with responsibility, especially within a system that has historically treated people unequally." His teaching style reflected his courtroom approach, methodical, evidence-based, but infused with a deep moral clarity that resonated with students. Beyond the classroom, Marcus had become an informal consultant to judicial reform efforts in multiple jurisdictions, providing guidance on investigation methodologies, data collection strategies, and implementation of accountability measures. His phone regularly rang with calls from attorneys, judges, and community activists seeking advice on addressing similar patterns in their local courts. The impact on young lawyers and law students proved to be one of the most enduring legacies of the investigation. Aisha Williams, the student who had witnessed Marcus's confrontation with Judge Wilson, established a court observer program that trained law students to document proceedings across South Carolina, creating both accountability and educational opportunities. "Watching that moment changed everything for me," she told a group of first-year students during orientation. I saw that the law could be a tool for systemic change, not just for maintaining the status quo. It showed me what ethical courage looks like in practice, not just in textbooks. Thomas Richardson, a recent graduate who had accepted a position with the public defender's office despite more lucrative offers from corporate firms, expressed a sentiment shared by many in his generation. What happened here in Charleston showed us that meaningful change is possible when people with privilege and position use it to address injustice, rather than benefit from it. That's the kind of lawyer I want to be. Law school applications in South Carolina increased by 32% the following year, with many applicants specifically citing the judicial reforms as motivation for pursuing legal careers. Enrollment in ethics courses and clinical programs focused on equity saw similar increases as students sought training that addressed systemic issues rather than merely technical legal skills. For community members who had experienced disparate treatment in the courts, the reforms represented both practical improvements and symbolic acknowledgement of long-ignored realities. Michael Townsend, the teacher who had been denied a payment plan under Judge Wilson, returned to court for a minor parking violation and experienced a dramatically different process. The judge looked me in the eye, listened to my explanation, and treated me like a human being deserving of respect, he recounted at a community forum. That might seem small to some people, but it meant everything to me. For the first time, I felt like I was actually getting equal justice, not just hearing empty words about it. An elderly resident of Liberty Hill who had lived through segregation and its aftermath perhaps captured the significance most poignantly. I've lived in Charleston for 82 years, and I never thought I'd see the day when our experiences would be validated, our concerns addressed, our humanity recognized in those courtrooms. It gives me hope that my grandchildren might actually experience the equality we've always been promised. For Marcus, these testimonials provided the most meaningful measure of impact. Reflecting on the journey during a quiet moment on his grandmother's porch, he considered what one person could truly accomplish. Systems don't change because of heroes, he told a colleague who had praised his courage. They change when ordinary people in particular positions choose to do what's right instead of what's easy. I just happened to be in a position to document what countless others had experienced for generations. The real change came from all of us refusing to accept injustice as inevitable. The newly established Judicial Ethics Center occupied the renovated east wing of the Charleston County Courthouse, its modern design featuring glass walls and open spaces, a symbolic commitment to transparency in a system long shrouded in opacity. 1 year after Marcus Johnson first walked up those courthouse steps to address a simple property tax issue, he now stood at a podium addressing judges, attorneys, law students, and community members gathered for the center's inauguration. Sunlight streamed through tall windows, illuminating faces both familiar and new, all united by a commitment to transform a flawed system. Governor Eleanor Mitchell, who had made judicial reform a centerpiece of her administration, introduced Marcus with evident respect. Some revelations shake our institutions to their foundations, forcing us to confront uncomfortable truths. But as painful as this process has been, Charleston's courts emerge stronger, fairer, and more worthy of the public trust they require to function. The man who catalyzed this transformation did not set out to create a movement. He simply refused to accept that justice should depend on who you are rather than what you've done. Justice isn't an abstract concept, Marcus began, his voice carrying through the hushed room. It lives or dies in courtrooms every day in the words judges choose, the time they allow people to speak, the fines they impose, and the respect they offer. It exists or vanishes in those moments when someone stands before the bench wondering if they'll be seen as a person worthy of dignity or merely a case number to be processed. He paused, looking across the diverse audience that included Miss Patterson, James Williams, and dozens of community members whose stories had contributed to the systemic changes now taking place. What we've learned over this past year is that justice requires vigilance. It demands that we pay attention, that we speak up when patterns emerge, and that we have the courage to challenge systems, even when doing so is uncomfortable. True equality before the law isn't achieved through grand pronouncements, but through thousands of daily interactions where each person receives the same measure of respect, consideration, and procedural fairness. His voice strengthened as he concluded, "The measure of our justice system isn't how it treats the powerful and privileged, but how it responds to those with the least power and the greatest vulnerability. When we ensure dignity and fairness for them, we fulfill the promise of equal justice for everyone." 1 month after the center's inauguration, the Charleston Municipal Court buzzed with the activity of a typical Monday morning, though the atmosphere bore little resemblance to the tension-filled space of a year earlier. Judge Amara Okafor, a respected civil rights attorney appointed to replace Judge Wilson, presided with a combination of efficiency and humanity that transformed the proceedings from adversarial confrontations to problem-solving sessions. The wooden benches now held a cross-section of Charleston's population college students with traffic violations seated beside construction workers addressing code compliance issues, elderly residents from Liberty Hill beside young professionals from south of Broad. Court officers greeted each entrant with the same professional courtesy, and the clerk's station featured a multilingual assistance desk where volunteers helped non-lawyers navigate paperwork and procedures. Most striking was the quality of interaction at the bench. Each defendant received direct eye contact, unrushed attention, and the opportunity to fully explain their circumstances before any judgment was rendered. When a young black man requested a payment plan for his fine, the standardized form and clear criteria resulted in immediate approval, the same consideration given minutes earlier to a white business owner with a parking violation. Despite the tangible progress, Marcus remained clear-eyed about the work still ahead. Changing policies is relatively straightforward compared to transforming culture and practice, he noted during a community update meeting. We've established better systems, but sustaining this progress requires continued vigilance from everyone involved: judges, attorneys, court staff, and most importantly, community members who experience these systems directly. The reforms had begun spreading beyond Charleston to other jurisdictions across South Carolina and neighboring states, but resistance remained in many courts accustomed to operating without scrutiny. This isn't a battle that can be won once and forever, Marcus cautioned. Each generation must defend and expand these principles, identifying new forms of disparity as they emerge and addressing them with the same commitment to fundamental fairness. As summer approached, Marcus stood on his grandmother's porch overlooking Liberty Hill, the evening light casting long shadows across the neighborhood where generations of his family had lived. The journey that began with a property tax dispute had transformed not just Charleston's courts, but his understanding of what change required and what one person could accomplish. Justice doesn't just happen, his grandmother had always told him. It's made by people brave enough to stand for it, even when standing alone. He now understood that courage wasn't the absence of fear, but the determination to act despite it, especially when confronting systems that affected countless lives beyond his own. The changing seasons marked the progression of both the investigation and the community's evolving relationship with its justice system. Marcus's first confrontation with Judge Wilson occurred during summer's unforgiving heat, the courthouse steps shimmering with humidity as he climbed them with his grandmother's tax documents. Autumn brought deepening investigation and falling leaves, nature's reminder that old structures must sometimes die to make way for renewal. Winter's stark branches and gray skies accompanied the tense period of Judge Wilson's resignation, when resistance to change seemed most entrenched. Spring arrived with the first tentative implementations of new procedures, uncertain and experimental, like early blooms. The full flourishing of summer once again brought the story full circle, with comprehensive reforms taking root as courthouse culture gradually transformed, mirroring nature's cycle of death and rebirth. The emotional journey of the investigation created a narrative arc punctuated by moments of profound human response. Early frustration manifested when Marcus first encountered the judge's dismissive treatment, his careful professional composure masking the internal recognition of a familiar pattern. Deep disappointment followed when respected colleagues suggested he let it go, revealing the comfort many found in maintaining broken systems. Quiet determination fueled late nights analyzing court records, the steady accumulation of evidence providing purpose despite growing pressure. Vindication arrived with the Commission's findings, validating what so many had experienced but couldn't prove. Uncertainty lingered during the transition period after Wilson's resignation. Would real change follow, or would new faces maintain old patterns? Hope emerged gradually through small victories. The first standardized payment plan approved without regard to race. The first courtroom observer program training session filled beyond capacity. The first judge requesting additional bias training rather than resisting it. These emotional touchpoints created a human context for systemic change, reminding everyone involved that abstract principles of justice ultimately affected real lives and communities. Emma Johnson's house in Liberty Hill stood as a powerful symbol throughout the narrative, representing both personal and historical stakes in the struggle for equal justice. The modest two-story home with its wraparound porch had witnessed generations of struggle and persistence long before Marcus was born. The property that had initially drawn Marcus into conflict with the court system became a visual reminder of why the fight mattered, representing all the families and communities whose relationship with justice had been fractured by systemic bias. Sunday dinners at the table continued regardless of what transpired in courtrooms or commission hearings, a reminder that beyond legal principles and institutional reforms lay the everyday lives of people affected by these systems. The house embodied resilience amid changing neighborhoods, holding on to core values while embracing necessary evolution, much like the justice system itself needed to preserve fundamental principles while adapting to more equitable practices. The Charleston County Courthouse architecture physically embodied the power dynamics at play throughout the narrative. Its imposing columns and elevated entrance created literal and figurative barriers between citizens and justice. The judge's bench, raised high above the courtroom floor, reinforced authority through physical elevation. The renovation process mirrored the systemic changes, removing unnecessary barriers, creating more welcoming spaces, and establishing literal transparency through glass walls and open designs. The transformation of physical space symbolized the shift from intimidation to accessibility, from concealment to accountability. Light and shadow recurred as visual motifs throughout the story, representing the contrast between truth and concealment, between justice openly administered and disparities hidden from public view. The harsh fluorescent lighting of the original courtroom cast unflattering shadows while revealing little, much like a system that proclaimed equality while practicing discrimination. The renovation brought natural light flooding through previously covered windows, illuminating corners long kept in darkness. Miss Patterson's secret notebook, maintained in shadows for years, finally brought to light truths that transformed the system. Marcus's investigation shined light on patterns long concealed behind judicial discretion and procedural complexity. Even the commission hearings were described in terms of bringing to light evidence that had existed in shadow. This visual metaphor extended to the Ethics Center's design, with its emphasis on glass walls and open spaces, a physical commitment that justice would no longer function in darkness. Have you ever wondered if justice truly is blind in American courtrooms? Consider your own community's legal system. Have you noticed patterns in how different people are treated? Does everyone who enters your local courthouse experience the same level of respect, attention, and procedural fairness regardless of their appearance, neighborhood, or socioeconomic status? If you were to sit in court for a full day, observing multiple cases involving different types of defendants, what patterns might emerge? How would you feel if your treatment in court depended more on who you are than what you did? What responsibility do legal professionals have when they observe disparities? If you witnessed systematic unfairness in a system you were part of, what would you risk to address it? These questions aren't theoretical. They represent daily realities in courtrooms across America that fundamentally affect public trust in our institutions of justice. Across America's courtrooms, troubling patterns persist in how justice is administered. Black defendants nationwide receive fines averaging 35% higher than white defendants for identical violations in some jurisdictions. Even when controlling for all legally relevant factors including prior records, offense severity, and representation status, sentencing disparities average 19.1% for the same criminal charges. Bail is set at amounts 35-45 higher for minority defendants than for white defendants accused of identical crimes with similar backgrounds. The financial impact extends beyond direct penalties. When unable to pay excessive fines, individuals often face cascading consequences including license suspensions, inability to work, additional violations, and sometimes incarceration for failure to pay, creating cycles of involvement with the justice system stemming from minor initial infractions. These disparities don't just affect criminal matters. Civil proceedings, including housing disputes, small claims, and family court matters, show similar patterns of differential treatment and outcomes based on race and socioeconomic factors. Perhaps most troubling, these disparities often remain invisible to those who don't experience them directly. The same system can function completely differently depending on who stands before it, creating parallel realities of justice in America that undermine the fundamental promise of equality under law. This story invites you to examine your own experiences and observations. Have you noticed patterns of differential treatment in institutions that are supposed to serve everyone equally? Perhaps in schools, government offices, healthcare facilities, or interactions with law enforcement. The power to create change begins with awareness, paying attention to these patterns in daily life, and being willing to name them when we see them. Small observations collectively can reveal larger systemic issues that might otherwise remain invisible. Consider keeping notes like Ms. Patterson did when you observe potential disparities. Documentation is a powerful tool for transformation. It transforms vague impressions into concrete evidence that can motivate change. Notice not just what happens, but who it happens to, looking for patterns that might indicate systemic rather than individual issues. Most importantly, recognize that systems don't change through passive observation. They change when people in positions of influence, privilege, or authority choose to use their position to address injustice, rather than benefit from or ignore it. Each of us occupies some position from which we can influence the systems we participate in, whether as professionals, community members, or simply as witnesses to how others are treated. If this story resonates with you, numerous resources exist to learn more about judicial fairness and equality. Consider attending public court sessions as an observer in your community. Research the backgrounds and records of judges who serve in your local courts, especially during election seasons. Support transparency initiatives that make court data publicly accessible. Engage with organizations working to ensure equal justice for all regardless of race, gender, or economic status. Court observer programs, legal aid societies, and community justice initiatives provide opportunities for direct involvement in creating more equitable systems. The path toward a more just society requires all of us to participate in ways both large and small.